It's my pleasure to introduce the next session, which has this wonderful title, From Deal to Delivery. And it's a great pleasure to have Ramin Hariri and Pirouzan Parvine and Navid Rahbar-Sato, please, gentlemen. Inevitably, of course, we are running, whoops, oh dear, this is a Madonna moment.
Do you have the control for the PowerPoint?
It should be there on the...
So probably you're just going to have it standing up.
Yeah, I mean, if someone has a PowerPoint, they can...
Okay.
So if you...
Have I managed to get my Madonna earpiece on properly? Yes, wonderful. Now...
We will be standing if you...
would you like to stand, or would you like to...
Yes, we'd like to stand.
All the time?
All the time.
God, you are tough people. I tell you what, everybody here, and then I think we should have Pirouzan to start. Yeah.
Sure. Thanks, everyone, for coming. We as Dentons are proud to be knowledge partners.
I'm going to sit, because I'm older than you.
Yeah, please have a seat. We're proud to be knowledge partners of this conference and this dialogue between Iranian side and European side for the third time in the row. And I must say that each time the location is improving. So I was wondering last night what Esfandiar could do for the next one. So Esfandiar, I think I have a challenge for you next year in the White House. So let's see. We are standing, maybe also because we are the optimistic guys in the room, probably, because we are in the middle of a number of deals. Not all have been closed yet. Some have been discussed for a long time. So basically, we are here for the deal-making side to help both sides, close the deal, actually, and go from talk to delivery. So we'll try to walk you through, the subject is very wide, but to walk you through some tips as to how to approach and structure the dialogue between the foreign side and the Iranian side to get as close as possible to signing the deal and to the delivery point. Ramin?
The first step would be obviously what we call pre-transactional phase, due diligence compliance. We're not going deep because we have discussed yesterday, this morning, on how to identify the real decision makers and what would be the impact of US and EU sanctions. They have different approach to the projects, and how to cover the risk of snapbacks. Of course, all of those are long debates and should be a part of this phase, preliminary phase. But what we want to stress more today is going deep into the Iranian context and Iranian regulation. Do I need a license, for example? Most of the activities in Iran, they need license. Yes, you have to go and see what is the process, how long it takes, and with whom you should do the applications. How to protect my investment. FIPA was mentioned many times, and FIPA, of course, it's a law which gives you protection and promotion of the law, but it's not only a law, it's an organization. FIPA is an organization which helps you to navigate around many ministries involved in your projects. And also, FIPA should be complemented by bilateral investment treaty, and this is a most easy and cost-effective way to protect its investment. Iran has entered into more than 50 bilateral investment treaties and more than 50 double tax treaties for many countries. If you choose your vehicle in one of those countries, you will, in addition to FIPA, have the protection of the international arbitration, and FIPA itself, we heard yesterday, says that if you want to be qualified as investor, you should be of one of the countries who have signed this bilateral investment treaty. And then it comes to the ownership. Ownership of in the particular sectors. Many sectors you cannot have 100% ownership. It is a banking, insurance, and if you, for example, go for local financing and loans, then there is a cap on your ownership. But ownership issue is also related of ownership of licenses, of ownership of permits. How transfer those permits, especially in mining, in oil and gas, and in construction sector. Then the big question is how I can finance my project. Today, this is the key issue of all of these billion-dollar projects, and the Iranian says, help us to pay you. How we can pay you? We are willing to pay. We have zero debts. We have money. The only problem is trust. It's not legal. It's not an obstacle to what we can. There is no, I mean, every tool is available. You have, Iran has been in the structured finance deals before. Buyer credit mechanism is very well known. You have mechanisms such as pre-export facilities. LC, there is one way is to have deferred payment LCs up to 12, 14 months. That would help the Iranian entity to take time to pay you. And those schemes are existing now. And someone has to manage, someone has to implement them. Once I've done all of this, it's to see what's the best structure for my deal, from corporate, tax. Should I have a joint venture in the country or offshore? That kind of transactional items have to be done before opening a dialogue for the deal.
So basically, this morning we will present you 2 points of view about the same subject. The one point of view is that we have combined for you is the point of view of the foreign investors, although Ramin and I are Iranian. Navid is Iranian qualified lawyer. So we have combined the point of view of Iranian qualified lawyer based in Tehran with our expertise as foreign advisors on Iran to present you some of our thoughts. So opening the dialogue from talk to deal, what we have noticed, and you have noticed probably as well, is in the press, and we're just talking about it this morning, how many times have we seen MOUs announced in the press? How many times have we seen letters of intent announced in the press, and then a sudden silence, right? How many times have we heard back from our client that they have signed an MOU, and then they're coming to us and say, well, we're stuck in the discussion. Our counterpart is changing the perimeters of the discussion, or sometimes we are in the middle of the agreement, we have drafted something, and suddenly we understand that there is a gap between us in understanding the goal. So the question is how to structure your dialogue in order to make it go through for both the benefit of the foreign side or European side and Iranian side. So basically what we propose at Dentons is to take aside MOU, letters of intent, and all declaration of intent, which might be needed, but don't count on it. Just make sure there's another document, because it might be needed sometime from the Iranian side, from his internal political or governance purposes, to show that the process is going on. They might just need that. But what we say is to actually go and prepare the next steps. And the next step is, we will speak in a moment about heads of terms, but the next step starts for the foreign side by making sure already at this very early stage it is protecting the environment in which the dialogue takes place, and that is the importance of the NDA and non-circumvent clauses, and the difference you have to be aware in Iran between confidentiality versus business secrets. Navid?
Exactly. As Pirouzan said, Iranians love to sign MOUs. I mean, like every day you just sign a document and then you just come after a meeting and then you have to say, okay, what happened? What did I sign? What did I disclose to my Iranian partner? You would be surprised to know that there is no protection of trade secrets generally under Iranian law. Like, no trade secrets. So they can disclose whatever they want, and you cannot sanction them. There's no criminal penalty. There is no civil damages that you can require from them. So that's why just signing an NDA, non-disclosure agreement, and even non-circumvention, because you just finish a deal and then the next day you will see, okay, they just signed a deal with another person, and then you are done. So, and that's why that is very essential. And of course, to draft it. And now we just wanted to go to the heads of terms that Pirouzan is going to take it over.
What Navid is saying is that there is not specific dishonesty on the Iranian side, is that the foreign side has to be aware and ready for the fact that the law, there's not legal framework for most of the areas defining what business secret is. Therefore, you have to define it in your documentation and have this consequence of breaching that in your documentation just to protect you. So, heads of terms, what they are standing for. When you have a deal in mind with your partner, you have a way to do your deal. You have done this deal in Germany before, in Italy before, in Africa before, in Russia before, and now you come to Iran and you expect that everything you say is, of course, understood exactly the same way by your Iranian counterpart. You have your deal parameters, which for you are usual. 12 years of sanction, it means that 12 years of globalization of the world and 12 years where the way to do business in the world has evolved. 12 years where you know that the management tools, the way to control finance in companies, even the softwares for doing so have changed. We have new business models such as the asset-light business model and even the factory-free business model, as you know. And therefore, there might be a gap, not in understanding, but in practice and approaching the way you want to do business by your Iranian counterpart. So basically laying down in the heads of terms in a single documentation the parameters of your deal is very important just to open the dialogue with your Iranian counterpart. What we advise you is not to rush and have your Iranian counterpart by any means very quickly sign on this document. It's just a document which you will share with your Iranian counterpart to just open the dialogue. For instance, cost of production, the way cost of production in an industrial JV is calculated in foreign jurisdiction, in Western jurisdiction, for instance, might be calculated a different way. Many times our clients have come back to us and say, we have a misunderstanding in what we calculate and take account for in the cost of production of certain goods. And there is a gap here. So these heads of terms, when you will define your budget, your business plan, the way you will build this, it will be an occasion to open the dialogue on these aspects. Also, on the foreign side, we have no clue of the idiosyncratic aspect of doing business in Iran. Who they have to pay, where they need some licenses, they need some steps. Things are not done exactly the way you do it in Western Europe. So the Iranian side has to be given the opportunity on very concrete parameters to also open the dialogue with you and say, this is your business model there, and I have these constraints in Iran myself. So it's very important that this document, you don't rush to sign it, but you go through and make sure you're on the same page in terms of understanding so that you go further. And sometimes you realize that you actually need to do some studies together before when you have an industrial project, before you actually go to the documents of the transaction, to the JV agreement, to the shareholders agreement. So the heads of terms can be combined or can become sometime a feasibility study before you actually sign a deal, take shares in the company of your partner, and so on. So basically, the pre-deal target you need to reach shall dictate the content of the pre-agreement you need to have agreed. Now, just a few tips on the various content of heads of terms. So basically, very quickly, heads of terms applied to M&A transactions, M&A deals, really from the foreign side means to explain and convey to your Iranian counterpart something that is very close to the content of a process letter in an M&A transaction in Western Europe. So basically, you need to convey to your Iranian counterpart disclosure, why disclosure of document is needed, in what form. You don't have a big habit in Iran, like in many countries, in many legal systems in transactions. So, for instance, Central Europe in the 90s, they were exactly at the same place. You didn't have data rooms, you didn't have virtual data rooms, so you need to explain the process, and the Iranian side perfectly can understand that when explained very clearly what the process, how the process has to be structured and why. There's no resistance on the Iranian side. There's just a communication and dialogue to take place to explain why you need that, what documents you need to review, what documents your advisor need to review, how they have to be organized in a data room, what does it mean, how the Q&A session means. So, heads of terms apply to M&A deals has many aspects, but one of the key features will be to already convey the way you want to see the deal go through, including to speak right there at the very beginning about your expectation on reps and warranties and a warranty of the reps and warranties. Heads of terms apply to industrial JV. I said a few words a minute ago. I just want to underline another fact, showing that how much heads of terms will help you to have the full dialogue before drafting a big agreement already with your counterpart to make sure you guys are on the same page. In Iran, at the moment where the JV could be liquidated or dissolved for any reasons, foreign companies cannot directly, without having an Iranian company in the middle, own land. So when your industrial JV, which very often has an underlying real estate asset on which it's built and operating, is going to be liquidated, you cannot benefit directly as a foreign shareholder from the land. You cannot become the owner of the land as a result of the liquidation proceeds. So you need already very early on at the moment of heads of terms, anticipate with your partner basically the formula. What will happen? Either you will anticipate that in such a case there will be basically sale of the land and division of proceeds, or there will be a formula for valorization, for evaluation and valorization of the land asset, so that when you divide, you leave the land assets to your Iranian counterpart, but at the agreed and predefined value, not the agreed amount, but the formula upon which the amount will be then decided. Otherwise, and we have seen in some deals that our clients are stuck with this problem because at the moment when the liquidation occurs, it's very difficult to negotiate the valorization of the land. Heads of terms apply to infrastructure and energy, Ramin.
You know that infrastructure and energy are of strategic importance in Iran. There are many political interference. They are also templates of agreement, but heads of terms would also apply. For example, for an airport or port project, the scheme would be a BOT or BLT, build, operate, and transfer. Government of Iran has published some guidelines on BOT, but guidelines based on UN model, but this is not adapted yet to the project. And for sometimes you're the first one going into such BOT agreement. So in order to facilitate the dialogue and the negotiation, one of the means is to have your concession agreement as usual in anywhere you're operating and adapt it to Iranian law. For example, the term concession is prohibited by the Iranian constitution. So you cannot call it a concession, but a BOT is a concession in some way, in some different way. So Iranian BOT is close to it. So in your heads of terms, you will have liabilities of the parties. You will have the usual standard clauses as to the scope of the construction and operation, how you finance the infrastructure, liabilities, termination clause, with some specifics for Iranian law. This would help you to navigate into the templates already available by the administrations.
Okay. There are some important issues that you need to address while drafting the terms of sheets or the head of terms. The first issue is that is it really necessary for you to incorporate your business within Iran if you want to do a business? If you want to have a joint venture, or you just wanted to set up your separate joint private stock company, And this question again gets back to the point that Ramin pointed out, which was very important. For example, we don't have any BIT with UAE. And many Chinese want us to do their business from there. So it's very important how you would like to structure that business, whether it's essential to incorporate it, whether it's not, in what structure you wanted to do it. Sometimes the fifth development plan, which is very important, we will see that they put some legal structure within a very temporary law, like with the fifth development plan, because after sixth development plan, that law is not going to exist anymore. But sometimes this is this contradiction that you will see in Iranian law. The next issue is that, can you have a shareholders agreement? Is it enforceable within Iranian legal system? The shareholders agreement that is going to affect every aspect of the heads of the terms. So we have to see to what extent you can agree on each terms and which one is enforceable. So Article 10, yes, Article 10 of Civil Code allows us to do that, but the thing is there are some specific regulations that stop us from doing it. The other issue is that, okay, we talked about the snapback clauses. How do you want to exit? And if you don't want to talk about it from the beginning, I would say it was just interesting to say that Iranians don't like about talking about the ending a relationship. They just hope. So that is very important. You just need to foresee everything from the beginning, because from the beginning, everyone is pretty kind. But when it gets to the end, it gets, you know that. And then, of course, the other term would be determination, liquidation. Pirouzan talked about the selling lands, that how you would like to terminate that, how we don't liquidate all the properties that you have in that specific vehicle that you have designed. So that is going to be very important, I guess, issue. Applicable law, I would say famous Swiss law. So we have this law in Iran that does not allow Iranians and foreigners to choose freely the applicable law, Article 968 of the Civil Code, unless you change the place of the conclusion of the agreement. That's why you will see many officials coming to Switzerland to sign
the Grand Older. We suggest that everybody comes to the Grand
here.
Older to sign agreement under Swiss law. That's a wonderful place for that.
So that is one of the issues that always have to be addressed. Sometimes Swiss law is not going to be the proper law for you. Sometimes Iranian law would provide you with more protection. I'm not saying this is always the case, but please, don't follow that path and template. And
just one subject. What we're talking here really about is that there is an automatism on the Iranian side to propose Swiss law. And what we suggest both parties is to reflect about what is the content of Swiss law. Very often we see then in arbitration, in dispute resolutions, that the parties had no clue about the actual consequences of opting for Swiss law. They have not studied Swiss law. Specifically, the Iranian side has sometimes picked Swiss law because, thinking that it's neutral. Switzerland is neutral politically, but the Swiss law is not necessarily neutral. You can guess that. So basically what we say, why not Swiss law? But you have to know, both sides has to know why it's picking up Swiss law. Many things are actually very nicely workable under Iranian law. You also can pick a foreign law under the certain conditions Navid just mentioned, but you anyway have to know why you're picking this foreign law and to what this foreign law will apply and what will be the limit. I would just give you one example. There will be always in a share deal, for instance, mandatory provisions of the local law. The transfer of shares in the Iranian company will never be ruled by the foreign law anyway. It is the commercial registry court that a judge there that will, and the provision of law that necessarily govern those change of titles in the shares. So if you are doing an M&A deal, or if you have a joint venture where you will enter into the shares of your partner, the company of your partner, you will know that all the disputes related to the title to the share will anyway be governed by mandatory provision of Iranian law. So again, this is just a side note with saying mysterious Swiss law. It's just to say, think really about what are the consequences of it. If you don't, why would you not choose Iranian law? And if you choose a foreign law, then exactly know why.
And dispute resolution. Of course, you talked about arbitration. Yesterday, they talked about Article 139 of the Constitution, about limitations as how you can defer your dispute to arbitrators. Of course, there is a specific interpretation for Article 139 that Iranian side, they can refer it, but if Iranian side wants to claim its right to arbitration, then it would get the permission. But always we have this question that when is that time that you need to go through? I'm not going to go through the content because it's going to be very lengthy, but the proper dispute resolution mechanism is very essential. Iranian arbitrators within Iran do not have the authority to issue any injunctive reliefs. So the other party can just take the money away, and then you have to just go away, get the award issued, and then enforce it until the New York Convention. So at the end of the day, that mechanism is going to be very important that you need to discuss it before.
Ramin?
Well, one of the hot topics today in Iran is the Iranian petroleum contract. We want to just give you some examples of issues our clients are asking of the coming tender process on IPC, which has to govern actually $100 billion projects over 5 years. Those figures are huge, and only one contract to govern that. So we thought necessary just to give you some example of issues that could be part of the negotiation. IPC has focused on collaboration, which is good. Means collaboration, means transfer of technology and know-how, means also that all the parties are equal. This is a major shift from the old buyback contracts that today the IPC proposes the joint venture scheme in the IPC. So everything we said on joint venture will be applied to the IPC. However, this joint venture is very complex. There is a joint steering committee for the exploration phase, and then you have a joint operating company for development and production phase. The management structure is not clear. Who decides what? What would be the implication of local partners? Iranians will promote local content, which is also good news, but this local content means participation of private Iranian companies, where we know there is no exploration and production, private companies in Iran. So who will be a part of those, the IPC, who will cover their costs? That's a major question. What percentage, at what phase the local partner will come in, and who will cover, is it a carry of interest or not? I will not go into the details because it's very technical, just to show you that these issues are the questions our clients are asking, and for each of them, we don't have clear answer. There is a margin of negotiation of the IPC because we are creating this contract, and this contract is very important for the future of Iran because it is the main agreements that will be negotiated within the few months.
Thank you. So basically, we have almost finished on time.
You are, yes, but we started late as well. But you are almost on time. That's
Excellent.
1 minute, 28 seconds. Fantastic. Brilliant performance. Thank you so much.
Thank you.
We really... And what also impresses me is that none of the chairs toppled off this platform. We are really about 15 minutes over time, but if there are a couple of questions, and there's a question here. But please, a brief question and very succinct
Philippe
answers.
Delors from Alstom. My question is from Ramin Hariri. You have spoken about BOT for infrastructure project. Is it true that according to Iranian law, having BOT makes possible to escape from tender and having direct negotiation, as some interlocutors told us?
Yes and no. The principle,
This is a very loyally answer.
the principle is tender. that is very clear. Above one threshold, the tender is mandatory. However, there is a mechanism with commission, derogation commission called abandonment of tender, and it's very transparent. It's not one person who decides that you're not going to tender. It's a commission depending on the sector and the amount. That could be at the level of the minister, the general manager of the company, and the Ministry of Finance. They will decide based on your proposal, does it make sense to have a direct negotiation or not? And then I think then it's possible to go to direct negotiations.
And Alstom has lots of
Maybe
power.
Navid wants to
I just
add.
wanted to just point something out. Iran is not a WTO member, so it means that we are not complying with the government procurement agreement that is, reflected in WTO agreements. It means that, and we have this law that Iranians can be preferred in all tenders, and this is something that you cannot object.
Yeah.
Something I would add very little. Sometimes our client says, this is a BOT, they ask us to put 1 million equity. Is this the law? We look at the law, no provision. We ask the ministry, why 1 million equity? They say, this is our own bylaws. So their own bylaws for that would be applicable, mandatory, provided that there is a tender. And there is no discrimination between you and other companies. Otherwise, it's not legal. We can reject it.
Okay. One final question, if there is one.
Yeah.
There, yes. Gentleman in the second row. I think, if I remember correctly, a hedge fund, is that right?
Yes, that's right, from G2 Metrics in New York. This is for Mr. Hariri on the IPCs. If you could just give us a little more insight into the structuring of the IPCs. Are these designed to accommodate a vertically integrated participation into the oil and gas sector, upstream all the way to downstream, or can they also accommodate more specific participation? And what is the nature of the JV? Is it in the form of straight equity, or is it with some kind of incentivization related to production targets or profit margins, or something else perhaps?
Very good question. Before the IPC, buybacks was dealing with only one piece, either exploration, development, and was a straightforward services agreement. The IPC is still a service agreement, but the first time in Iran, after the end of concession, we have integration possible. Not mandatory, but possible. So you can have from development to commercialization, and even further to LNG and downstream, if you want to. In this case, you have to link the downstream and upstream with another contract, of course, but it's possible. But you also can enter in any phase, exploration, EOR, which is the enhanced oil recovery, where Iran needs hugely foreign technology. You can just go to EOR. So it's very flexible in terms of integration. That's the first question. The second question also is flexible. You can, for the first phase, there is no incorporated joint venture, but joint operating company is a joint venture company incorporated. So after the commercial discovery of oil, you will enter into phase of development and operation, and therefore you should implement, according to our knowledge of IPC, that could change, but they were consistent until today on that point. And this joint operation company is a joint venture between IOC, NIOC, and a local Iranian company.
Ramin, Navid, Pirouzan, thank you so
Thank
much.
you.
Thank you.
Brilliant presentation. Thank you.